And we will continue today with the next rings of jurisprudence. Remember that all knowledge and also in this career is you have first one basic notions and you build another and another, just well, learning more things. But we are at the very beginning, the nucleus of this career, jurisprudence. So for today, we have the next learning objectives. First, today we will see the history of legal tradition, how codes appear, what is the difference between common law and civil law, and a little of another system. And you will have many ideas about this, you will see. And the background, the historical background, that is so important. Then we'll see a quite different thing related to the last one, but is quite different. It is the historical school. Now we will begin with authors, and we will see these authors say that, these authors say that, these authors said that. I prefer, there are a lot of authors around the world in every country. I will give more time for those authors that have or had in the past a lot of influence, and probably some of the ideas that we have in our mind today is because of them. So this is a very influential school of thought, legal thought. So then we will see the anthropological jurisprudence, more or less related to the last one also. You will see that it's like a line, but quite different approach, based more or less in some similar ideas, but not exactly the same. And finally, we will see social theories of the law. So there we will see, for example, well, many authors, Marx, for example, that is famous, and another that probably for you now are not that famous, but you will hear about them. So let's begin with the first topic, history of legal traditions and code. So, well, I think that, I don't know if you know them, Ulpian and Justinian, who they were in the past. Any one of you know at least one thing that is quite interesting and why they are so important for the law? So let me, okay, I'm putting here. Okay, no one of you remember these authors, so don't worry, because that this lecture is for. We will begin understanding more or less the civil law system. So it more or less is based on the Roman law. So everything began in the Roman, not empire, in the Roman kingdom. Remember that Rome had in the past all kind of systems. At the very beginning was more or less a clan of families. Then it was a kingdom. Many kings reigned there. After that was the republic. When Rome conquered Greece, they took the example of them, and they became a republic. And after that, the empire, the final stage, and with the empire was the last part. So what happened at the very beginning when was so small Rome? It was just in Italy. In Italy, Well, was a few families, and when they had problems, what they did, they used to go to a reasonable man, more or less. Who is the reasonable man? Well, probably elders, many other people, probably, to resolve their cases. No? When kings were instituted, when kings took control of Rome, Rome was at that time a little bigger. Yeah, it was the beginning of the expansion of Rome, and they put some authorities. But at the end of the day, who has the power to decide cases? Well, the king, obviously, but also there were many, well, praetors, people that knows very well what is the law. So people used to go to them to ask about some advice how to resolve my case. So it was so important. Normally, not just the authority, the power of the king, but also, especially at the very beginning, what the genius of the law, the jurist, said about what is the law. Because everyone more or less believed that the law should be just and should be reasonable. That is the idea. After that was the Republic. The Republic. In the Republic, they had a Senate and a lot of people that governing in a democracy. And they, well, as you see, the institution of the authorities, the institutionalization was better than in the past, and they have more power over the people, and the sense of what is the law. This was again more or less at the you have two sources. First one, the power of the authorities, and second, the greatest jurist of all times. So imagine that, and many things that people used to say in the past was the law, because the law was reasonable, and everyone believed more or less that there was a law in our nature, especially the Stoics. You know, Cicero was a Stoic who realized that there is not just the laws of the will of human beings, but there is another thing, no, related to the gods, to the gods. So you will remember the painting of our last lecture, Antigone. Antigone appealed to the laws of the gods, no? And she said that they are superior to the laws of the king, more or less. But at that time, I will remember just one idea. They used to mix every kind of law. The antique citizen of Rome and everyone in the world, uh, everyone in the world used to mix. There was no separation, distinction between the law of the state, the law of religion, the law of morality. They are all of them more or less the same thing. So what is the law? Probably you have to ask to the priest of that time, of the pagan temples, to see what is the law at the very beginning, no? And also to the greatest jurist of Rome, and also, well, to see what the king and the judge used to say. But there was a develop, and in the Republic also there was the 12 tables. I don't know if you have heard about that. A synthesis of the law in big tables that the authorities put everywhere, well, to show what is the law, no? And you will read here, and every citizen will know what is the law. As you can see, yeah, it's very important because Rome was very big at that time, and also with a lot of years. Rome was founded, was created in, I think, well, 18th century before Christ. So imagine that, no? A city and then a country with more than 1,000 years. Yeah, they will have a lot of laws, a lot of statutory laws, regulation, policies, a lot of case law also, and a lot of also great jurists. In 1,000 years, you will realize now they will have marvelous things. So what happened after that? That there was a lot of things. And after that, the empire, one Caesar August, and then another, and they put with more power even, no? Because was more or less the emperor of whole Europe and in the north of Africa and part of Asia. So it was so big, no? The emperor of Rome was the most powerful guy in the world, absolutely, absolutely, without any doubt. So, so there, after 1,000 years, there were a lot of things, and to study law was a little tricky, a little difficult to study so many laws, so many authors. So one emperor, Justinian, and many other people tried to put all these laws in one book, all these laws. But remember that the law at that time was not the Britain law, was not the case law. Principally was how our greatest people or genius of the law understood uh, what was the law, what was the law. So they decided to put in all laws in some books, no? And well, as I told you, the classical Roman law is in the period of the first 3 centuries, even before 1 century before Christ was also Cicero, and they put all of the laws in some books. For example, in the Digest, in the Codex, the Institute. Well, we will see this later. So Ulpian began with the organization, but finally the Emperor Justinian asked for many jurists to put everything in order in one book. That book, more or less, that book with many parts, obviously, it will be called Corpus Juris Civilis, the corpus of jus civilis, no, civil law, of civil law, the corpus of, and that is quite interesting. Was not exactly a code like we have today. You open a code, criminal code, and you will see. If you do that, you will be punished in this way. If you do that, you will be punished in this way. And the what you can do and the consequence, more or less. That is the idea of the typical codes of today. No, at that time was so different, the code. The code, remember, was what was the law, not just what the emperor, the king said in the past, that was, no, or the 12 tables, no, principally what the genius of the law said was the law. What was the law? Well, they say this. So the code simply put is a list of phrases of the jurists, of the greatest jurists of Rome. So in this topic, they put a title and they say, Gallo said this. Tap, copy paste. Then second, but also you have to remember that Cicero said that. And then they will put, and also, don't you know, Ulpian, it was written in the 5th, 6th century, you know. Ulpian, 3 centuries ago, said that the justice was that, no? And indeed, the digest begin with a phrase of Ulpian. What is justice? And they say justice is the constant and perpetual will of giving each one what is entitled for, more or less. So that is a copy of the things that the greatest people of Rome in the last 1,000 years said what was the law. Okay, so it's quite different. It's not the coding in the way that we understand today. So that is quite interesting to understand, because what happened after that? You will remember that Rome fall. Rome fell, I don't know, the fourth, fifth, sixth century, one part, then later another part. Each part at the beginning, the other part. And in Italy, in the fifth century before Christ, obviously. Fifth, sixth century before Christ. This was one of the last emperors, the last famous, obviously. After that, there were some other, but not with that power, and the empire moved to another place. But there was no Rome after that. And remember, the whole Europe was unified with one big legal system, the whole Europe. And just a little part of the UK, but then no longer was Rome in the UK, in the islands, I mean. So what it means? That after the falling of Rome, there was no one authority. There was many invasions from the north, from the south, or the east. So what they tried to do, to survive. Every citizen wanted to survive, and if you are in a farm and you see that the people from the north are trying and coming for war, for a battle, you will try to save your life. You will knock the doors of the city and say, well, I swear you loyalty and I will give you whatever you want, but please help me and protect me. And that's why the whole Europe was built like small cities with big walls to protect themselves. The farmers and the people of the wild swear loyalty to one king, and that was the beginning fiefdom. That was the fiefdom scheme, no? So the circumstances, the situation in Europe changes dramatically. Yeah, there was no single authority, and during many centuries they forgot what was the Roman law. But what happened after some centuries? In the 11th century, there in Rome, in Bologna, one city, they discover again the Corpus Juris Civilis. They discover, oh wow, look at that, what amazing. We were thinking that we have a great system. It is not a great system. What is the greatest one? Well, that one of Rome, no? That is in this book. And they discovered the greatest juries of 1,000 years. But because the situation in Europe changed dramatically, what they do, well, try to understand better a little what they say, because many things they can apply to that situation, to their circumstances. But many other was so different because there was no emperor of Europe. And so they realized that they have to understand better the code. So in this way, the professors of that time used to write before the phrases of Gallo, Cicero, Sallustio, and many others, and some comments. That comments in Latin are called glossa. So that's why they are called the commentators or the glossators, no? Glossators, because they put some comments there in that book. And that was so interesting because was the fashion how to study the law, to study that book, the Corpus Juris Civilis. The Corpus Juris Civilis. If you want to study the law at that time, if you are a law student, at that time, they will give you one book that is the Corpus Juris Civilis. You have to study and to read the comments of the greatest professors of Italy at that time. And if you want to be a very good student of the law, well, they will give you not just one book, they will give you a second book. That is the Corpus Juris Canonici. The Corpus Juris Canonici. What was that? That, as you see, is a century later. The Corpus Juris Canonici was more or less the same idea that of Justinian. This is 12th century. And the church had at that time also 1,000 years of life, the Christian church. No? So with 1,000 years of life, there were many things, no? Many provisions of the authorities, or the priests in their parish, of the bishops. There were many case law, how to resolve, for example, a husband and a wife that had some problems. They don't know if their marriage is valid or not. Well, someone will resolve that, and this will be a case law. How to resolve these cases? Well, and you will have a lot of case laws after 1,000 years. 1,000 years, imagine that. Huh? So you will have and also some policies of the authorities on how to do this and how to do that. So one clever guy called Gratianus in that century decided, well, let's put order here. Let's put everything that we have in a systematical way in a corpus, no? So in the same way that Justinian did the first Corpus Juris Civilis, they put in the order. But remember, it was not you should do that. No, but it was this authors say that this was their solution, and this is my point of view, Gratianus' point of view, for example. No, and they brought a second Corpus Juris Canonici. And this is quite interesting because after that, that was so successful that every university in Europe, in the Christian world at that time, to explain what is the law, they explained with the Corpus Juris Civilis, and for the good students that wanted to have two titles, no? Not just a lawyer in the state, for example, but lawyer also in the church, the ecclesiastic law. They will give you a second code that is Corpus Juris Canonici. If you study both, they will give you a title that was called a lawyer in utroque ius, and one and another law. That is in English, in the translation. So that is quite interesting. So you know now how your colleagues 1,000 years ago studied the law. We are studying a little different by Zoom. They didn't have Zoom. So for sure you will know who is that guy with the hand here. Who is? No one of you? No, you should know. You should know. Yes, Marsui. Marsui.
Is it Napoleon?
Yeah, really, very good, very good. It's Napoleon Bonaparte. Bonaparte was a clever guy, a very clever guy with a lot of strategy, but so he was able to conquer with more or less a small army whole Europe, the whole Europe. But at the end of the day, he lost everything. It's incredible. But also was a good lawyer. He was also not a lawyer. He began as a soldier, as a regular soldier, and at the last was the emperor of France, and more than the emperor of Europe. He tried to put all Europe against in one hand, the control of one emperor, but he lost everything. In any case, at one point, uh, someone also, uh, well, he realized that it's important to put order. We had many laws in the past. There was the French Revolution. There was a lot of chaos in the French Revolution. Many people died. And he said, well, after the antique laws of the antique regime and the laws of the French Revolution, there are a lot of problems. Let's put order and we will create a new code, Really, it was not the first that created some code. In some other countries, for example, in Prussia, in Austria, in Germany, Bavaria, there were many little codes that put every law about one specific topic in one part. But he says, let's put everything that is the law in one code. This is century 18. The situation in Europe was so different. There was no more fiefdoms, small cities with one small king that governs the city more or less. But 5 centuries, 8 centuries before that, after that, there were in Europe big kingdoms, not the small kingdoms, but big kingdoms, and big kingdoms with a lot of power. The king will have a lot of power, not just a power in one city, but if a power in a lot of places in Europe. So, at the beginning of the 18th century, well, at the end of the 18th century, at the beginning of the 19th century, the most powerful country was France. And because this guy, Napoleon Bonaparte, that was a clever guy in war. So he said, well, let's create one big code. No? The Napoleonic Civic Code. They use more or less some of the idea that they have in their mind. They were studying also the Corpus Juris Civilis, but many other things, also the customs, the authorities, the laws, and they put, and with that power, because he was once again the emperor of France, he said, let's put in a systematic way what I say, what is the law, and everything that is the law should be in this code. And if that something is not in the code, is not the law. That was the idea. If something is not in the code, it's not the law. What is the law at that time? Well, what Napoleon Bonaparte said was what was the law. No. So imagine that, no, a kingdom, an emperor with a lot of power. You cannot say, no, for me the law is no, because you will be punished. No, you have to follow what Napoleon or emperor or the greatest of the French people say what was the law. And that's what was very interesting, because it was a school of thought, no? How we understand the law. Well, you can read, obviously, and everything should be in the code. And obviously, if there is a gap, the code will have the answer with our general principles. But if you don't understand what is the law, try to think what Napoleon said that was the law. He was really clever in every area. Also in family law, was incredible. So at that time, well, he created that. After that was a revolution in whole Europe, no? So they realized that France was so advanced and they had nothing. So immediately, many countries tried to copy some similar codes using more or less the same. For example, the Austrian Civil Code was approved soon later. uh, uh, because they had small codes, and then he put everything together and approved immediately. And well, there were many other codes in Poland, in Spain, in America also. In America, well, in America, yeah, there were many little civil codes, more or less copy paste of that one of Napoleon. Also in Asia, some countries put the codes and copy paste and changes little things, not so deep change. So the influence of the French vision of what is the law was incredible around the world. Incredible, because was so interesting. No? But in Germany there was one guy that opposed to Napoleon. We will see. Savigny is the name. We will see this guy. And that's why they wait. They wait 1 century, more or less, to approve their code, because there was one guy that, no, this is not good for ourselves. In the UK, they were in another kind of system. And there were many people that, for example, Bentham say, we have to have one code. We are going with our old fashion of doing things, and let's go better with a precise code that will say we'll avoid the bad ideas and the corruption of the judges. But it never happened, as you know. They didn't approve at the time one civil code. That is quite interesting. And what happened? This is the story of civil law. The civil legal systems around the world was supported on that. No? And remember, France was part of Europe. They copied, they studied the Corpus Juris Civilis and also the Corpus Juris Canonici, and that both were the source of the Napoleonic Code. And there was a lot of understandings of what is the law. You will know a little more later. But that is the civil law, and that's why it was spread around the world so deep in this century specifically. And now we have two big traditions now: the civil law, and then the common law. The common law, you should know what was the origin of the civil and the common law, don't you? Any one of you can share an idea of the origin of the common law? What was the beginning of your legal system? What do you think? The origin of the common law. Because we will compare later both. But I already explained the civil law system, and now the common law system. What are the difference? Yes, Abigail.
I'm not sure, but I think it originated from the King's Courts. Yeah.
Okay. But before the King's Court, there was many things. The King's Court appeared, well, very late, when the kings had a lot of power. But there is one geographical difference between the UK and the continent of Europe. The UK are many islands. There are many islands, and that is quite interesting for the creation of the common law. Why? Why? Because if you are living in an island very far, and your king is in another island, and it's so difficult to travel, it's not so. And if you have one problem, what you will do? You will go to travel one day and risking your life in winter. No, probably you will try to find someone to solve your case in your island. So at the very beginning, especially first century, 2 centuries, there was a chaos. There were many groups there, and they decided, well, let's try to find one reasonable man, the same as in the very beginning of Rome, one reasonable man here to resolve our case. The same that happened in many places here in Africa, no? Try to find one reasonable man to resolve. Many times is the elders, is one elder, or a community of elders, or whatever you want. There are many systems here in Africa. So the smartest of the island will say, you have the right. You have the right. Well, and the case was solved, was decided. But after that, after 1, 2, 3 months, someone appeared with the same case, more or less, what they will see. You say that if this happened, this should be the consequence. So you cannot say now any different answer. And what it means, if you say something, the case decided in the past should bind the next case. You should repeat the same judgment. And after that, another, and another, and another. No? And why? Because people used to believe that was reasonable. That was reasonable. It was part of the common sense of the people, no? Of the common understanding of the people. And the law was something reasonable. And for anyone was, obviously, if you are clever, you will get the answer easily. If you're not that clever, well, you will not discover very well. That's why let's go to a reasonable man to resolve. No? But this is grounded on reason. On reason. So little by little, in many islands, there were a set of case law, and then the kingdom, well, with more power, will impose their power there, but they will say, no, we have judges. Later, 6th century, 7th century, and you should respect this set of cases. That is our tradition, and is the common sense of what everyone in the world will understand what is the law. And centuries later, the kings will have more power and they will lose them. They will lose little by little that power, and now they have not that power. But this case of law was a set of cases that decide what you should do. In this case, you should do this. In this case, you should do this. So it was more or less a general law. And that's why at one point, if you put a general law, there should be exceptions, because many times and there was, well, the circumstances were not identical, exactly the same that in the past, and you should put one exception. So they decided, well, let's create an exception. That was the beginning of equity law. Some exceptions, principally, if you want some special procedure, well, let's not try to use this set of cases, but no. And that's why you have now two sources of the law. One, the common law cases and the equity cases, no? And you can apply or this, more or less that is the beginning. And after that, well, say, well, 4th, 15th century, Edward Coke said that we are the judges. He was a great judge. We are over the king. So the king should obey the court. And that was, well, so if you want to know the difference between both systems, you will get with the history. That is quite interesting, no? So the origin of the civil law was the Roman law, as I mentioned to you, no? And the origin of the common law was the jus commune of all these islands that are in the UK, more or less, and well, as collection of case law, and then the principal powers in each legal system are the legislative power in the civil law. Remember that guy, Napoleon Bonaparte. What is the law? What Napoleon said. But after that, there was no a guy with that power. That was the parliament, more or less, no? And in the common law, principally is the judicial power. That is interesting to know. That is, by the way, this is a generalization. So you can find a lot of exceptions. I found many of these ideas in many places, in many authors around the world. And principally today, there is a mix of things here in the common law system and there in the civil law system. So in many places, well, judicial power have more power than the legislative power. I mean, in South America, for example, now especially with the constitutional movement. But in any case, more or less, this can give you one idea of the difference between both systems. Not general ideas, no? You should study each country to understand how things are in each country, no? But a general idea is good to have. Well, in the civil law system, laws are mainly contained in codes, no? Very precise text which contain everything, no? By the way, no country achieved the ideal, the goal of putting all laws in a code, because soon after that, France published a second code, the criminal code, and then another. So the goal was not achieved until today, no? But in any case, the idea of organizing this provision with a structure in a very clear way that everyone can read, that more or less it was achieved. So in the civil law is principally a lot of codifications with very precise text. No? And people in the universities there in South America and in Spain, to study the law, most of the time is to study what the code say. And if the code says something, first you have to study, and then you can study another things, no? What the authors say, but the law is what is in the code. In the common law system, always you have some statute laws, but principally you have to study cases. And this is quite different, no? Because the cases have a lot of nuance, a lot of details, no? So many times it's hard to get the rule from one case law. But in any case, that is the way of studying things. The judicial precedent normally in the civil law is not binding. Once again, in some countries, one specific areas is binding, but not for everything. In the common law, normally is binding because the origin, as I told you, is there's the common sense. If it is really common sense, you should apply the same reason later. It's more or less the idea. The division of law, well, in the civil law system, they say private and public law. You know that you have also something similar. But and now this is a little different. I'm copying here what one author said. But so you can have something similar here. But in the civil law system, you don't have this division. The common law and equity law, they don't have that. They don't have that. Is clear. In the civil law system, the judges decide the cases, no? And also what are the facts. In the common law, well, you have judges and jury normally for the facts, no? In any case, once again, you can find countries that don't use that, or in the civil law system that use judges and juries. So, but in any case, as a guideline, you can see this. The process, how is the process in the civil law? People used to say that is more inquisitorial, no? Yeah, some process could be more inquisitorial than in the common law, that is more adversarial. It means here the parties, the lawyers used to dominate and to follow the process. Well, the civil law more or less, no, it's no, you have very similar things. But in any case, the judge in the past was so clear, had more power to continue the process till the end, no? And to ask for evidence. Now, in so many places, no. But in any case, as a guideline. And deception, obviously, deception to the laws of the process, to put remedies. Now, both systems, by the way, have some kind of remedies to the problem. No, but in the common law, it seems to be that there is more flexibility. Judges can apply many different remedies, that the equitable remedies, to have a fair judgment. Instead of that, in the civil law is more rigid, because remember, what is the law, what is in the code, and it's not in the code, wow, there is a problem. If something is not in the code, in the civil law system, there is a big problem, because people will say, no, it's not in the code, it's not the law. That is not the law. I have many cases in my country as a lawyer. I mean, I litigated many times, and that was a big problem. If something is not written, well, to convince a judge or a public officer what is the law is so difficult, so difficult. Here, at least as a guideline, well, it's easier to explain what is the law as a guideline. So, any question about the distinction between the civil law and the common law system? I don't know if you have any question. Not at all. Okay. So, because I will show you now a map. More or less, this is the UK, Europe. Here you have in this color what is the common law system, and in blue the civil law system. As you see in France, well, this was the source. Remember the Roman Empire, and then France, and its code, that code of Napoleon, that was spread around Europe and around the world. So now in the world we have everything like that. More or less this here. You have the colors to understand better. That is quite interesting, no? So the civil law is the main system now in most of the countries of the world, the civil law system. Also in China, you can see here, no? They use, well, what is the law? What is written, no? More or less, and you have to follow this. There is some difference. Japan also follows more or less the French code. Many countries here in Africa, almost the whole South America and Central America. Why? Because Spain conquered, invaded all this part, and also part of the United States, but then it was invaded by the new colonies, the 13 colonies invaded Spain here, and that's why here you have some parts that are more similar to the civil law, and it's a mix of common law and civil law, especially in Louisiana, in the States, and in the north, because the French had some colonies here, and that's why it's a mix. It's a mix here, civil law and common law, and more or less the same happened in South Africa, that have a mix. Quite different is in India. It's principally the customary law, still there. They have a lot of tribes with a lot of traditions there, quite different. And this part is quite different. And also the Muslim law. You have in many countries that is quite different. Basically, one book, one sacred book, as you know. Well, more or less, this is the map in the world. So it's interesting to understand, and obviously the colonies of the UK received the common law cases, and they are developing now, as you know, their own cases of common law and equity law. So each one with a little difference, but that based in the previous one. Normally they used to say, from the day of the Independence Day, we will develop our own cases, and before that we will receive that. More or less that is in most of the countries that were colony of the UK. Okay, so after that we will see now the historical school. Let's continue with the historical school.